Most states,
Not you, New Jersey.
no New Jerseys, but yeah, in most states they are not fire. I mean, they're not firearms under the federal definition. They're not firearms under most states' law. Some states are going to say felons also can't carry yada 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 yada, but for the most part, yeah, and definitely here in Texas. We're the Arms Attorneys. Today we are back with another mailbag episode. Stick around. We're going to talk about a Hearing Protection Act update. We're going to talk Byrnas, and we're going to talk about when your personal life can be brought into the courtroom. But before we get started, show your support for the Second Amendment by hitting the like button.
And we got a full docket today. We got a full sheet. So let's just start it off with Apache Paul. Off topic, but relevant today, is a Molotov cocktail an imminent deadly threat before it is lit? That's the part I was waiting to see your I was looking for your initial reaction, and then I want to see the rest of your reaction.
Before it's lit, before it's thrown. So I love this. I actually pulled this question. I love this question because there are instances in which a known weapon is not a threat before someone threatens you with it, right? I mean, think somebody carrying a baseball bat could look very, I mean, there are instances where you're like, all right, that's a threat right off the bat. Carrying a skateboard,
or
right?
I think of like a sword in a sheath.
Sure.
Yeah.
Sure, for all the sword carriers out there.
Yeah.
So yeah, I mean, there are, for sure, there are times when you're like, well, they're carrying something and you know that it could hurt you, but you really gotta wait till they're like kind of starting to look like they're gonna hurt
When you
you
see
with
the lighter
it.
going,
Well, I was gonna say, this is, I mean, yes, you still have to wait for imminence, but you don't have to wait as long because there's not an innocent use to a Molotov cocktail.
not that I've seen.
I
I could
mean,
be.
is it just dark outside?
Sure.
Light the wick. I mean, no, there's right. So this is one of those scenarios in which, like, I'm trying to think of something else that's really, really never going to be innocent. And this is about the best example because, like, you can be open carrying a handgun in a holster, right?
Well, it's because
That's fine.
I mean,
that's different. This is just a weapon.
well, it's kind of like you see the premeditation associated with causing serious bodily injury or death, property damage, in a way that, person's carrying a handgun. Guess what? Lots of people carry handguns. Police carry handguns, innocent use, self-defense reasons. You don't really see a whole lot of defensive Molotov cocktail use.
Yeah, someone's just got a machete in their hands in the middle of downtown. Like that's close to me in my mind,
Sure.
right? You're not in the field, right? So like
They're just scraping it on the ground.
this is a zombie movie. Yes. So, I mean, I think absolutely. I mean, you see someone, I mean, that's at least worth, it's not lit, it's not thrown, someone's just got one in their hands. I mean, other circumstances depending, that is at least an opportunity for a use of force, go tackle the person. I mean, there are, potentially even draw your handgun and say, stop right there. I mean, I wouldn't shoot him yet before
Sure.
it progresses, but like you can start on your force continuum 100%.
Well, and it's all about imminence, right? Because we see that pop up in self-defense. Virtually every single state has some kind of element of immediately necessary, or if the person's about to use or attempt to use unlawful force or deadly force. So your state's law is going to impact this a little bit, but this is one of those, I haven't seen a case that addresses this, a self-defense use against a cocktail like this. It's a really interesting hypothetical.
It is a very interesting hypothetical. I was excited when I saw it, Apache Paul. Okay, we have at Gary and Trisha 1. Will you be at Goals again this year? Richard, will you be at?
I really hope so. So Goals is going to
should
be
be.
August the 9th and 10th in Knoxville, Tennessee. This is Gun Owners of America national convention. This is the second time they've done it. The first one, I was actually so blown away at how great a job GOA did.
Yeah, they did great.
Usually it takes a few years to like figure stuff out, figure out the kinks, get people there. This was, I will say, a grand slam for their being their first one. So I would be very happy to be there. I think there's a very high likelihood that I'll be there. I don't think you'll be there though.
I will not be there. It will probably be Richard and Edwin.
Yeah, maybe
Richard and Leslie. I will either be in labor or have a newborn. So I will not be there. And although I almost went into labor at the NRA convention that one year,
yeah.
remember? I missed that by just a couple hours. That was at least in Houston.
Yeah.
So I'm not going to risk it. I will not be at goals this year.
All right, next one from Timothy Grote, 5609. So if the Hearing Protection Act passes and it's legal in my state to own a suppressor, does that mean that I could build my own? Does it have to be serialized? So there's a couple hypotheticals built into this.
There are a couple hypotheticals. So we do not know. And someone was like really hard on us the other day. I don't know if you saw, they're like, well, you could just read the budget bill and figure these things out. And it's like, okay, first of all, no, because I have to feed my family by taking actual clients. So I will read the reports of what's in the budget bill at this point.
I've read the substance
we've read the substance of the Hearing Protection Act. Also, it's
still being negotiated.
Exactly. Speculation at this point is fine. We can all speculate wildly. Whatever is currently written in what the House has passed is absolutely meaningless. Absolutely meaningless. So to that, whatever grouchy old man wrote that a couple weeks ago, it's been living rent free in my head because I just remembered it. But no. So the answer is, I don't know. I mean, as it currently stands, it would be far more likely that your suppressor is still a 4473 item. At that point, could you manufacture your own in the same way that you can manufacture your own other 4473 items? Perhaps.
Yeah, I would say that's probably the most likely scenario. They're treated just like a Gun Control Act firearm. Maybe assembling this thing whole cloth. If it's unregulated, if you could build a firearm under your state's law, then you should be just fine.
But is that a consideration they put in? They're like, hey, we're cool with someone walking into the gun store, filling out a 4473. We're not cool with, your homemades. I mean, I could certainly see that being something that is at issue here. So
the Senate can do, they literally can do anything at this point.
Yes. So we do not know. We do not know the answer, but it is a fascinating consideration and something we should all definitely be thinking about. Like, what kind of world would we live in if this happens?
Yeah.
But we don't know yet.
And I'll say that just the latest on Short Act, their pressure is mounting to get the Short Act back in there. So again, it looks like Hearing Protection Act has a very high likelihood of making it through the reconciliation process. Short Act, I'll say lesser of a chance. That's the world we live in today. This information's changing.
I'm going to say absolutely no on the Short Act because I said that about the Hearing Protection Act and I was wrong. So I think maybe I'm like reverse jinxing it if I guess in the negative. There, prediction.
Locked in.
Okay. All right. So now we've got at KAN Disc Full. When can your personal life be admissible in court? From what I've heard, the prosecution can't bring up your personal life as it's considered hearsay and irrelevant to the facts of the case at hand. I think the prosecution for Kyle Rittenhouse got a spank. Okay. Because they tried to say Kyle chose to remain silent until trial. I just don't like to think of the lawyers at trial getting spankings because it's either me or it's someone that I really hate in the moment, and it just seems like I want them to get punched in the face.
So generally,
with their hearsay.
Why is personal life admissible, not admissible? It's really going to depend. It's a judge's call ultimately. But typically, when you are in trial for guilt or innocence, all that should be before the court, the jury, is did this thing happen? Did this not happen? And then we're looking at pieces of evidence. Does this tend to show more likely than not or not? Did this happen or did this not happen? And the general rule is relevant evidence is admissible, irrelevant evidence not admissible. But sometimes, there's exceptions to the exception to the exception.
Right. There's all sorts of things that fall into that, right? It's like relevance, yes, your general standard, but then is it more, you got your 103 balance, right? Is it more prejudicial than probative? Then you've got does it, when in my law school, we called it, because this is what Tracy George called it in our class, the propensity box.
Okay.
That was my professor. So does it fall into the propensity box? Because if it is only relevant because it makes your action, it makes your propensity, like your trait for this thing, more or less likely, not allowed. So generally speaking, if, I don't know, let's say that I am a habitual dog kicker and then I'm being prosecuted for animal cruelty. and the state wants to say she has kicked 3 dogs on 3 different occasions in her past, that's probably not admissible because it has nothing to do with the allegation of that day. It's propensity box evidence. You seal it up and you put it away. So I don't know. There's a lot, like Richard said, there's layers upon layers upon layers.
So let's say you're charged with like a drug crime and you go on the stand and say, I've never, I'm not into that culture. I've never done this. And okay, maybe a picture of your apartment with your box.
You just opened your propensity
box. Then you opened your box. Because
basically
it would be misleading to the jury to, if you left them with that impression, guess what? The opposing party gets to try to correct that misimpression. So maybe they, at that point, can show a picture, of your college dorm with your Bob Marley poster and your bong sitting all over your coffee table.
Right.
So, I mean, it's a very complicated thing, but general rule, personal stuff, not relevant outside of the incident. But, there's always exceptions to the exception.
Yes. And take into consideration the fact that judges do stupid things and make dumb decisions. And then you have to deal with whether or not it was an abuse of discretion and whether or not it
caused harmful error.
Caused harm. Right. So, yes. The rules as they apply hypothetically are not always the rules as they apply in the courtroom. So it's all very complicated.
All right, next one we have James Hamilton, 8907. This is specific to Texas, but I think it's something that folks can extrapolate outside. Can felons carry a Byrna in Texas? The short answer is yeah.
Absolutely they can. And in fact, most states,
not you, New Jersey,
New Jersey's, but yeah, in most states they are not they're not firearms under the federal definition. They're not firearms under most states' law. Some states are going to say felons also can't carry yada 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 yada, but for the most part, yeah, and definitely here in Texas.
Yeah, I'd say to find out in your state, look at the definition of what constitutes a firearm. If it looks anything like the federal definition where it's expelling a projectile based on the burning or explosion of a substance, well, guess what? Those Byrna devices, they use pressurized air.
Yep.
But some states will, here's if you want to double check your work, are these pressurized air guns, do they just write those into the definition and say, we consider these firearms? If they do, you might need to pump the brakes a little bit, especially if you're falling into one of the prohibited person categories.
Yep, absolutely. Okay, this is at Klaus Jaeger, 1493. Do you think he's German?
Maybe. The evidence is mounting.
This is in response to us complaining about Brett Kavanaugh. I didn't read this one beforehand, so I'm going in blind. Is the Supreme Court compromised now? Okay, so he wasn't mad at us for complaining about Kavanaugh. All right.
But we did. I mean, we had a video talking about, hey, look, they denied certiorari on Snope. This was the assault weapons, air quotes, eye roll.
There were a lot of Kavanaugh defenders in our comments, I will say that, which I was surprised by.
Well, our friend Gary in Montana had a really good theory, and I wanted to share it, and that's why I picked this question. His thinking is, and I agree with this, there are no coincidences in politics, but maybe Kavanaugh was saving us from ourselves because they didn't have the votes. And that's why he did the deny cert, but hey, look, I still think this is the way it should go. That's it. I like assuming good intent sometimes.
Yeah, I mean, so, well, yeah, you know what? I suppose, because we only have 4, and then you get down to Roberts and Coney Barrett, and Lord only knows what weird political goat sacrifices have to be made to get them on board. So, I don't know. Okay, yeah, fair enough. I'll take it.
What ceremonies have to take place in front of the giant owl?
Yeah,
yeah, sure.
Exactly.
All right, this is for you. Number 1 actual honest question: why is statutory law allowed to include words that are factually incorrect, false, or etc.? Assault weapons is a factually false term. Why is that allowed in the law and allowed to be included in the law or discussions about the law?
I don't have a good answer. I mean, you're right. Assault weapons, totally fake, made up term. We use it on this channel when discussing specific statutory provisions because we are quoting the law and words are important. I guess because lawmakers can write any damn thing they want.
Yeah, they can write a definition.
You got to just deal with it. I mean, it's an interesting thought question as to like why do they just get to make up terms like that? And they write the law, they get to make the definitions. I don't know. Do you have anything else?
No, I mean, that's the short and truth of it. The legislature writes the meaning of words. That's it.
Yep. So, oh, it's our friend. We actually know him IRL. Anthony.
Oh, yeah.
Yeah. All right. Wait, is this yours?
No.
No, this is mine.
Okay.
At Anthony, Guardian Survival Tools. Thank you for being a consistent watcher. Emily Richard, in Texas and most other states, can't virtually any negligent discharge be charged as deadly conduct if it occurs around a habitation, vehicle, or building. Have you seen charges filed for a negligent discharge?
Have you ever seen someone charged for Yes. All the time. It happens all the time. And You know what? It drives me bananas. Guess what? Accidents aren't crimes.
Correct. So that brings us to one of my favorite things to talk about, which is mental states, mens reas, right? Because you have negligence, not a crime, and you have recklessness, which is the mens rea by which you can charge deadly conduct, even ag assault, deadly weapon, things of this nature. And so the fight in court, these get charged all the time. And the fight in court is, was it negligence? Was it simply a deviation from the general standard of care, your sort of ordinary duty to other people? Or was it recklessness?
Were you aware of a substantial and unjustifiable risk and you just consciously disregarded it? Because when we hear about negligent discharges, obviously, safe firearms practices, we want all that stuff. We don't want folks to have negligent discharges because I know that people say there's no such thing as accidents. Mm-hmm. But is that, you're aware that your gun is loaded and you don't care, and so you're going to... No, that's the standard of recklessness. And so as far as crimes go, most of these negligent discharges are not reckless.
Right. Although Leslie had one the other day. So yes, like I've gotten a whole bunch where people have like dropped guns, just instinctively caught them, finger and trigger well, discharged, like very clearly negligence. Leslie got one the other day and I was like, oh, like, heck yeah, dog, you can get, that's a negligent discharge. Let's get it dismissed real fast. And she was like, well, he was dry firing at the wall in his apartment where he knew there was an apartment right behind him. And he didn't check to make sure it was unloaded. He just feels like he always leaves it unloaded. And so he just picked it up with a magazine in it, pointed at the wall and fired, and was like, oh crap, I didn't realize it was loaded. Like,
first one, clearly a mistake, but the
second one,
the seventh and eighth one. No, I'm just kidding. It wasn't that many.
No, but like that sounds a lot more like recklessness to me. Like before you start dry firing in an apartment building, you don't even take the magazine out and like clear it and make sure like. And that's coming from a gun rights lady who doesn't want to see people charged.
Yeah, but do folks get charged for negligent discharge?
Yes,
all the stinking time. Yeah. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please, as always, question and comment for us below. That's where we get your questions for next week's episode. Until next time, we're the Armstrongs.